Welcome, everybody. Welcome to, excuse me, today's episode of the Law of Self-Defense. So glad you could all be here today, Monday, May 20th. The time flies. Time flies when we are having fun. No question about that. And today we are here to talk about this, the Alec Baldwin case. Earlier this month, his lawyers filed the motion to dismiss the indictment against Alec Baldwin. This is different than the motion we covered on Saturday in that hearing. This is an argument that the indictment should be dismissed because even if everything the prosecution says is true, Alec Baldwin's shooting of Halyna Hutchins is still not a crime. So we're going to cover that. We'll go through the motion itself. We'll also, before we get to the motion, we'll cover some general principles and doctrines of law, criminal recklessness law, the handling of inherently dangerous instruments like a gun, how those are generally treated under New Mexico law. And then we'll go through the defense motion. Now, the defense motion is likely to cite lots of different case law and make all kinds of arguments that I expect I will find to be tenuous arguments at best. But this is the job that Alec Baldwin's hired these Manhattan attorneys for, is to leave no stone unturned, to make every argument, no matter how ridiculous, in defense of their client. Nothing wrong with that. Nothing wrong with that. That's what they're supposed to do. Zealously advocate for their client, Alec Baldwin. It is one of the reasons the prosecution team, Carrie Morrissey, Special Prosecutor Jason Bowles, and not Jason Bowles. Bowles was Hannah Gutierrez's attorney. Jason. Darn it. Jason. Let's see. I feel bad. I'm not remembering his name. I can't remember Jason's last name. Sorry about that, folks. And the just appointed third party on the prosecutor team, Erlinda O. Johnson, who is a career prosecutor. Carrie Morrissey, of course, is a career defense attorney who's simply working as a prosecutor by special appointment in this Rust movie shooting series of criminal trials. So it is one of the reasons Carrie Morrissey's brought on Erlinda O. Johnson as a third lead member of the prosecution team, because it's obvious that the defense team, which has now, I think, 7 or 8 different lawyers involved to one degree or another in Alec Baldwin's defense, one of their strategies is going to be to just kind of overwhelm the prosecution team with various motions. And that's allowed. It's part of the strategy, of course, of the defense. What we're going to take a look at is the credibility of this particular motion, which was filed actually 2 weeks ago today, just came to my attention yesterday, actually, which is why I'm addressing it now. So, before I jump into today's show, I do want to mention something else, and that is an unrelated case, another criminal prosecution, and that is the prosecution and upcoming sentencing of Marilyn Mosby. Dear to my heart, Marilyn Mosby. If you don't know, Marilyn Mosby was the state's attorney in Baltimore when a small-time street corner drug dealer, Freddie Gray, was arrested in a drug sweep in Baltimore by the Baltimore Police Department. He saw the police coming. The police have been spent by special instruction to clear out an open-air drug market in Baltimore. Freddie Gray was one of the people dealing drugs there. He saw the police coming. He fled. The police pursued. They tackled him to the ground. They arrested him. He was non-compliant with arrest. He was handcuffed. He was put in the back of a police van. By all appearances, in perfect health. There was never any indication that any excessive force had been used against him. But when he was pulled out of the police van a while later, he had a broken neck. He would die of that broken neck 7 or 10 days after the injury occurred. And the An investigation ensued, as one would expect to be the case. And the investigation was about to be announced that there was no evidence that any of the officers involved in Freddie Gray's arrest or transport had done anything wrong to Freddie Gray. In fact, the medical examiner's report was that the broken neck was akin to a shallow diving injury. As you might imagine, if you're on the edge of the shallow end of a pool and you dive in and it's too shallow, you hit your head on the bottom, causes a neck injury. That was the reasoned theory of the case of the medical examiner here. Freddie Gray was in a police van, not buckled in, as was the normal practice for Baltimore PD. He's just on a bench inside the van. But he's handcuffed behind his back. And we all know, we've all been on buses and trains and such. And if you stand up and you're not holding on to anything by choice or because your hands are handcuffed behind your back, and that vehicle stops for a red light or a stop sign or traffic, you, under the laws of motion, tend to continue moving forward, right? That's why they have straps and bars to hang on to. The thinking is that Freddie Gray decided to stand up, crouched in the back of this transport, and it stopped for a red light, a traffic sign, traffic, whatever. And he kept moving forward, falling onto his head against the bulkhead at the front of the transport area of the van, hit his head like a shallow diving incident. Perfectly consistent with his injuries, completely innocent explanation for Freddie Gray's injuries and why he died. And the police investigation was just about to be announced to that effect. When Marilyn Mosby called the press conference in front of the courthouse, on the steps, the big steps, the grandiose columns behind her, and she announced that she was bringing charges as serious as murder against 6 of the police officers involved in Freddie Gray's arrest and transport. When asked the basis for these charges, she said, well, I've conducted my own independent parallel investigation. So I have evidence that the other investigators don't have. This would later be proven to be a lie. She does have an investigative function within her office as state's attorney. But that poor fellow, when lawsuits started flying around, said, listen, I don't know what anyone's talking about. We never, the state's attorney's office never investigated anything. So she just made that up. In the complete absence of evidence that any of these 6 officers, by the way, roughly half of whom it was a very mixed group, both gender and race-based. There was a couple of white cops, a couple of black cops, male cops, female cops. In the complete absence that any of these officers had done anything wrong, zero evidence, any of them had used any force against Freddie Gray's neck, for example, she decided to prosecute them for charges as serious as murder. Ultimately, they would all either be acquitted at a bench trial, or the charges ultimately would be dismissed when it became clear that there was never going to be a conviction on the facts of this case. Of course, those cops were facing potentially the rest of their life in prison. By the way, when they were administratively investigated after they were acquitted or had their criminal charges dismissed, no wrongdoing was found. There was no sanction of employment at all, because these cops had literally done nothing wrong. So Marilyn Mosby had engaged in this really brutal witch hunt of these 6 officers. Why? Why would she do that? Part of the reason is this sweep of the open-air drug market had been at the request of the local politician, Baltimore politician in that district. He'd gotten complaints from his constituents saying, hey, they're selling drugs everywhere. Can you do something, councilman, to maybe clear these drug dealers out of our neighborhood for a while? Turns out that councilman was married to Marilyn Mosby, the state's attorney. So he asked his wife, Marilyn, could you maybe ask the police department to sweep out these drug dealers? And she said, sure, honey, I'd be happy to do that. And when the state's attorney asked the police department to do something like this, the police department, which works closely with the state's attorney's office on a regular basis, says, sure, we'll do the sweep. They did the sweep. Freddie Gray ends up dead. And Marilyn Mosby's primary concern is her welfare and her husband's, at the time, welfare. So what did she do to deflect attention from herself, that she was the person who requested the open-air drug market sweep that ultimately resulted in Freddie Gray's death? To deflect attention from herself, She prosecuted a half dozen Baltimore police officers on zero evidence that any of them had done anything wrong. That is heinous. Now, some of those officers would later try to sue her. Those lawsuits were dismissed on the grounds that, as a prosecutor, Marilyn Mosby had absolute qualified immunity from those civil suits. I think that was the wrong call. I think she gave up qualified immunity, which would apply to legitimate acts in the course of her work as prosecutor. I think she gave up qualified immunity when she lied about this investigation. That was the basis for the charges against the officers. Lying about an investigation that didn't happen, that you know damn well didn't happen, that's not part of your normal job as a prosecutor. In fact, I think that should be subject to prosecution. But in any case, the civil suits were dismissed, and Marilyn Mosby got reelected. And then she ran into troubles of her own making. In particularly during the COVID period, she committed perjury. She's been convicted of this now. She's been in 2 different trials. She committed perjury to take advantage of some of the policies that were implemented during COVID for people who were in distress from the insane, irrational, vindictive COVID policies that were in place, where people could withdraw money from retirement accounts and other accounts without penalty, the normal penalties that would apply. Marilyn Mosby withdrew that money, lied about the reasons for withdrawing it, and used it to buy a couple of vacation homes. She was caught in these lies. She was charged for perjury and filing these false documents. She's been convicted in 2 separate trials of this perjury, and her sentencing is coming up. And she's looking at 40 years in prison. And all I can say about that is it couldn't have happened to a more appropriate person. And with that, let's go ahead and start the formal launch of today's show. If there's a big smile on my face, that's why. Here we go. All right. So today's show is brought to us by our sponsor and frequent partner, CCW Safe. CCW Safe is a provider of legal service memberships, what many people mistakenly call self-defense insurance, in part because a big part of what CCW Safe does is cover its members' legal expenses if the member is involved in a use of force event and is compelled to use force in defense of themselves, their family, their property, and then faces criminal or civil liability afterwards, or at least claims of criminal or civil liability. They do much more than just pay legal bills. They also fly in your own investigative team. Otherwise, the only investigators work for the prosecutor, folks, and do much, much more. I do a lot of partnering with CCW Safe. I think the world of those guys. I trust them to have my back when it comes to this type of coverage. I'm personally a member of CCW Safe. My wife, Emily, is personally a member. Now, there are other companies out there that offer purportedly similar types of coverage. Some of them are quite reasonable and worthy of consideration. Others are a dumpster fire, which I cannot recommend under any circumstances. And none of them are inexpensive, folks. So don't be paying hundreds of dollars a year for something that's a dumpster fire. Be making an informed decision. And I would urge you, as part of that consideration, to look at CCW Safe. If you'd like to learn exactly why I trust them, why I feel they're the best fit for me, and maybe they're the best fit for you, go to lawofselfdefense.com/trust. And there I have a little video explaining exactly why they are my choice, why I trust CCW Safe, lawofselfdefense.com/trust. And when you go there, you'll also find a 10% discount code you can use when you apply for your own CCW Safe membership. Again, that's lawofselfdefense.com/trust. All right, so let's talk about this motion. This motion by the Baldwin defense team. Defendant Alec Baldwin's motion to dismiss the indictment for failure to allege a criminal offense. So effectively what the defense here is saying is, even if everything the state says is true, our client Alec Baldwin still did not commit the crime of involuntary manslaughter under New Mexico law. And because of that, the indictment should be dismissed. Because again, even if the state could prove beyond a reasonable doubt everything they're claiming in the indictment at trial, it's still a rational jury could still not convict because it still doesn't prove a crime. And we'll go through their specific language, but essentially what they're saying is, and because what is the state claiming? The state is claiming that Alec Baldwin knew he was holding a real gun in his hand, pointed the muzzle of that gun directly at Halyna Hutchins, cocked the hammer, pressed the trigger, dropped the hammer without ensuring there was no live ammo in the gun. In fact, there was live ammo in the gun. That live ammo discharged. That bullet struck Halyna Hutchins in the armpit on the right side, traversed her body, broke her spine, exited the left side of her body, and buried itself in the shoulder of Joel Souza. That none of that amounts to a crime on the part of Alec Baldwin. That as far as criminal liability, Alec Baldwin's completely in the clear, simply does not amount to a crime. Obviously, the state disagrees. That's why they charged him with involuntary manslaughter. Well, what is the New Mexico law on involuntary manslaughter? Let me do this. Let me pull it up in Lexis because the version I have here is unnecessarily abbreviated. Give me 1 second. Let's see. There's New Mexico. There's the statutes. Statute number is 30-2-3. Manslaughter. Just so I'm being thorough. So this is the crime with which Alec Baldwin is being charged, manslaughter. See if I can make this a little bigger. Now, of course, there's voluntary manslaughter, which is manslaughter committed in the heat of passion, hot blood. That's an intentional killing, but in the heat of passion. That's not what we're talking about here. No one's arguing that Alec Baldwin intentionally killed Halyna Hutchins, cinematographer Halyna Hutchins, on the set of Rust. The state's arguing that Alec Baldwin committed involuntary manslaughter. And there's two ways to commit involuntary manslaughter under New Mexico law. One is manslaughter committed, and of course, manslaughter is just a form of homicide. It's an unlawful, unjustified killing that's less than murder, than an intentional, premeditated killing. Involuntary manslaughter consists of manslaughter committed in the commission of an unlawful act, not amounting to a felony, because if it were a felony conduct and it resulted in a killing, that would be felony murder, and the punishment would be essentially the same as murder. That's not what's being argued here. An unlawful act not amounting to a felony, and here the unlawful act being alleged is negligent use of a firearm, negligent handling of a firearm, which is a crime under New Mexico law. And that would be the predicate underlying crime for this branch of involuntary manslaughter. And we'll look at that statute next. So the commission of an unlawful act not amounting to a felony, or in the commission of a lawful act, so the state doesn't have to prove that the underlying conduct was itself a crime, which might produce death in an unlawful manner, meaning it wasn't justified. The shooting of Halyna Hutchins obviously wasn't justified self-defense. Baldwin's not claiming that. Or without due caution or circumspection. So that's an or, right? So the second branch to get to involuntary manslaughter is that it consists of manslaughter committed in the commission of a lawful act which might produce death in an unlawful manner, or a lawful act without due caution and circumspection that results in the manslaughter. By the way, I've seen argument. We had a commenter on Saturday arguing that, well, in his opinion, Alec Baldwin meets the due caution and circumspection standard because, and therefore this could not have been manslaughter, involuntary manslaughter, because of the presence of a armorer on set and the fact that the David Hall, the first assistant director, he was the overall manager of safety on the set. And Alec Baldwin knew that David Hall had that responsibility. And Alec Baldwin knew that Hannah Gutierrez was the armorer handling the firearms. And his knowledge of that, and arguably his management of that, Alec Baldwin was a producer on this movie set, meets the requirement of due caution and circumspection. So the first thing I would point out is that even if you believe that's true, and I'll show you why it's not reasonable to believe that's true, even if you believe that's true, that's not the only way to get to involuntary manslaughter, because another way is lawful act, which might produce death in an unlawful manner, not justified, that results in manslaughter. That can apply here on the facts of this case. Or that this was an unlawful act. This was negligent handling of a firearm by Alec Baldwin, and that amounted to manslaughter. But I don't believe that you can credibly argue that the managerial responsibility of safety by David Hall, the first assistant director, or the presence of an armorer, Hannah Gutierrez, satisfies the due caution and circumspection requirement. Because what that would mean is that Alec Baldwin had no further responsibility for the safe handling of that gun, what he knew to be a real gun in his hand. That he had no subsequent responsibility for any negative consequences in his handling of that gun, because David Hall managed safety on set and Hannah Gutierrez was the armorer. But even the movie industry doesn't believe that's true. Now, I've talked previously about how the SAG guidelines for gun safety cannot help Alec Baldwin and can only hurt Alec Baldwin. So what I mean by that is, to the extent that the SAG guidelines would be argued to be more relaxed and forgiving of Alec Baldwin's handling of the firearm, that can't help him in an involuntary manslaughter prosecution in New Mexico, because the SAG guidelines are not New Mexico law. SAG is not a law-making body anywhere, and particularly not New Mexico. New Mexico criminal law is created by its elected legislature, signed by the governor, or by New Mexico case law, appellate court decisions. The Screen Actors Guild does not create New Mexico law. So to the extent that the Screen Actor Guild's guidelines would be more forgiving for Alec Baldwin than New Mexico criminal law, that cannot help Alec Baldwin in a New Mexico criminal prosecution, because SAG guidelines cannot trump New Mexico criminal law. Now, those guidelines can hurt Alec Baldwin if they are perfectly parallel, equal to the requirements of New Mexico criminal law, or they're even stricter than New Mexico criminal law. That could be used to hurt him, because you could argue, not only does New Mexico criminal law say Alec Baldwin's guilty, but his own industry guidelines say he's guilty, that he failed to meet the standard of due care and circumspection. So if anyone's arguing that the presence of David Hall, assistant director, manager, overall manager of safety, and the presence of Hannah Gutierrez, the armorer, that under industry guidelines that would relieve Alec Baldwin of any further responsibility for safe gun handling, well, all you have to do is look at SAG's own guidelines. As an actor, you are ultimately responsible for your own safety and the safety of your fellow crew cast members. It is your right and responsibility to double check the setup to ensure your own safety. So you can't say as an actor that other people are responsible and that relieves you of a safety obligation. Everybody is responsible for safety, including the actor. But it gets worse when we get to the firearm specific safety guidelines. This is SAG Safety Bulletin, Screen Actors Guild Safety Bulletin number 1, firearms. Does this say that the safety protocols for the handling of firearms ends with the armorer and the first assistant director? Did the Screen Actor Guild's Firearm Safety Bulletin guidelines say, actors, you have no responsibility for how you handle a firearm on set, because that responsibility ends with the first assistant director and the armorer? That meets the standard for safe handling of a firearm. After that, you can do whatever you want as the actor. No, it doesn't say that. Responsibility for safe handling of a firearm continues when the gun is in the actor's hand. After the first assistant director and the armorer have relieved themselves of the gun. How do we know? Because it tells us explicitly. Because there are a ton of safety requirements imposed on the actor after the armorer and assistant director roles are done, imposed on the actor in the safe handling of a firearm. Refrain to the actor. These are all instructions to the actor. Refrain from pointing a firearm at anyone. Did Alec Baldwin do that? Did he point a firearm at someone? He sure pointed it at Halyna Hutchins, didn't he? Did that responsibility end with the first assistant director and Hannah Gutierrez, the armorer? No, not according to SAG. Any object at which you point a firearm could be destroyed. Why do they want the actor to be aware of that? Because the actor still has responsibility for how he's handling that real gun. Never place your finger on the trigger until you're ready to shoot. Is that directed at the first assistant director or the armorer? It's the actor's responsibility. He doesn't get to do whatever he wants with his trigger finger just because an armorer and assistant director exist. Never lay down a firearm or leave it unattended. Again, this is a requirement for the actor. He's not relieved of this because the set has a first assistant director and an armorer. Even SAG continues to impose safety standards on the actor, despite the presence of an armorer and first assistant director who's general manager of overall safety. So no, if you're arguing that the presence of the armorer and the first assistant director relieves the actor of further responsibility, that satisfies the due care and circumspection requirement under New Mexico involuntary manslaughter law, I'd have to say you simply don't have a leg to stand on. Not just under New Mexico law, but under SAG industry guidelines itself. All right. So back to this. Oh, actually, we were looking at the statute, weren't we? So really three paths here to get to a conviction for involuntary manslaughter. There's the lawful act paths, lawful act, and then two ways, two additions, right? Whoops, let me get there. It's hard to get all these fingers on the screen. So Alec Baldwin was engaged. I don't know where those balloons come from. How did somebody do that? Is it because, is it detecting my thumbs up? Did one of you do that? Is that the audience that does that? I really don't know. So we have the lawful act path, which has two alternative additional elements that collectively constitute involuntary manslaughter. Lawful act, which might produce death. So you know it could produce death. It might produce death. It's not normally a criminal act. It's a lawful act that might produce death and death results. Involuntary manslaughter. Or lawful act without due caution and circumspection. That's way one and way two to get to involuntary manslaughter. And then there's unlawful act, that Alec Baldwin was engaged in an unlawful act and not amounting to a felony, and a death, an unjustified death resulted. That unlawful act, the underlying predicate unlawful act that the state will be arguing, is a separate criminal statute under New Mexico law. That's negligent handling of a firearm. Now, we're going to look at the negligent handling of a firearm statute in just a moment. But before we do, I want to point out that what that statute does explicitly is reflect a legal doctrine I want to share with all of you now. And that's the doctrine of an inherently dangerous instrument. So We all have a generalized legal duty not to cause harm to other people. And if you are negligent in causing harm to other people, you have civil liability to them. You're responsible for the cost of the damages you inflict, destruction of property, wrongful death, whatever the case might be. But negligence by itself, so you were not aware you were creating a risk to others, but you should have been. A reasonable and prudent person would have known that your conduct was creating this risk. It was not unforeseeable. It was foreseeable. You should have foreseen that you were creating this risk, but you weren't consciously thinking about it. That's negligence. Negligence is only sufficient for civil liability, monetary damages. You can't be sent to prison by the state for merely negligent conduct. There's a higher standard called recklessness, where under recklessness, you knew that you were creating a risk. In this context, a risk of death to others. So we're talking about a reckless homicide, involuntary manslaughter. You knew you were creating a risk of death, and you consciously disregarded that risk, and death resulted. And the classic example is drunk driving. You go to a bar, you get drunk, you're going to drive home. You get behind the wheel and drive home drunk. Now, you're not intending to run anybody over and kill them on the way home. If you were intending to kill someone and you killed them, it would be murder, right? You're not intending. You just want to get home. You're drunk, you want to go home. You want to go to sleep. But we all know that if you're drunk driving, you are creating an unjustified risk of death to others. And if in the course of driving home drunk, you run somebody over in a crosswalk and kill them, that's reckless conduct. You knew you were creating an unjustified risk of death to others. You ignored that risk. Death resulted. That is involuntary manslaughter. Recklessness, that knowing disregard of an unjustified risk, does give rise to criminal liability. That's what makes it different than mere negligence. Negligence is here, civil liability. Recklessness is here, criminal liability. But there's a way to jump from mere civil negligence to criminal recklessness without having to prove that the person involved consciously knew of the risk. And that is if the risk is the result of them handling an inherently dangerous instrument. Because if you're handling an inherently dangerous instrument, something all people would know, carries inherently, if mishandled, a risk of death or serious bodily injury. There's no way that someone handling an inherently dangerous instrument could not be aware of that risk. It's presumed that they possess that knowledge because of the nature of the instrument, because it's inherently dangerous. And they mishandle it, and death results. It's presumed they had a conscious knowledge and disregarded that unjustified risk of death. It's automatically recklessness, and therefore carries criminal liability. So what's an inherently dangerous instrument? Well, it would be something like dangerous chemicals. So you know it's a dangerous chemical, right? It's not a vial of mystery liquid. It says cyanide on it. It's maybe dangerous pharmaceuticals. It says fentanyl. It's got a skull and crossbones. Heavy equipment, cranes. You're lifting 10,000 pounds above a metro street as part of building a skyscraper. If you do that incompetently, you know there's no way not to know that you're creating a risk of death or serious bodily injury, an unjustified risk. And firearms. Firearms are inherently dangerous instruments. Everybody knows that firearms, if mishandled, can readily kill or cause serious bodily injury. Nobody doesn't know that. And by the way, that would be especially true of someone who spent decades of their life acting in movies, handling real guns, and being trained on every single one of those movie sets on the dangers of handling real firearms and the practices necessary to do that safely. So guns are an inherently dangerous instrument, which means if you're handling a gun in a manner that for some other object might be merely negligence and only civil liability, because you're handling an inherently dangerous instrument, the gun, it automatically jumps up to criminal liability, to recklessness. And how do we know that New Mexico recognizes this kind of generalized doctrine I've just described, like you might hear it in a law school class? Because New Mexico says so. In criminal statute 30-7-4, negligent use of a deadly weapon. This is a criminal offense right here at the top, Chapter 30, criminal offenses. This is not a cause of action for a civil suit, a criminal offense. Negligent use of a deadly weapon. Is a real gun a deadly weapon? Of course. Negligent use of a deadly weapon consists of, and we're looking here at this third option. I hate it when Lexus does that. Endangering the safety of another by handling or using a firearm or other deadly weapon in a negligent manner. So what you're doing would normally just be negligence. It doesn't say in a reckless manner. It doesn't require that you knew you were creating an unjustified risk and affirmatively ignored that risk. Mere negligence is enough. You should have known, even if you didn't consciously know. The state doesn't have to prove you consciously know. You should have known that the manner in which you were handling that gun could endanger the safety of another. When you do that, you act negligently, normally only good for civil liability, in the context of a firearm. It is a misdemeanor, a crime. And of course, that's an unlawful activity, which ties back into this. Involuntary manslaughter consists of manslaughter committed in the commission of an unlawful act not amounting to a felony. That's that misdemeanor negligent handling of a firearm. And so we can see from this negligent handling of a firearm statute that when you're handling a firearm or deadly weapon, an inherently dangerous instrument, in a merely negligent way, it automatically gets bumped up to recklessness, criminal liability. So, and of course, intuitively, we all understand this, right? So in firearms training, for example, there are, for training purposes, there are things you can buy called blue guns. A blue gun, often they're blue in color, which is where the name comes from. A blue gun is a plastic replica of a firearm. Could be a pistol. It could be a long gun. I've seen them in shotguns and AR pattern rifles. I guess it could be almost anything. But let's focus here on handguns. There's you can buy blue gun versions of most popular models of handguns. It's a replica, feels similar in the hand, looks similar, but it's distinctly colored blue, and it is a solid piece of plastic. It is completely inert. Ammo cannot be loaded into it. Ammo cannot be fired into it. It is literally a hunk of plastic and easily identifiable as such. And we use that for training purposes like weapons retention, wrestling in the context of going hands-on in the context of handguns, because the physical dimensions of the blue gun are similar to a real gun. So in that respect, the handling of it is similar for training purposes. But there is obviously zero risk of causing death or serious bodily injury with this inert piece of plastic. If I were to walk up to you and point what's obviously what you recognize as a blue gun at you, you'd have no reason, and you wouldn't be in fear of death or serious bodily injury. You might say, why is Andrew pointing a blue gun at me? But you would know there's no danger of death or physical injury, serious bodily injury. If I were to walk up to you with what you knew to be a real gun and point it at you, would you then be in fear of death or serious bodily injury? Of course. It's a real gun. Real guns discharge real bullets. Real bullets kill and maim people. What if I walked up to you and I pointed a real gun at you and I said, and you said, "Is that loaded?" And I said, "I don't know. I don't know if it's loaded." Would that relieve your concern about me presenting you with a threat of death or serious bodily injury by pointing a real gun at you when I tell you that I actually don't know if it's loaded or not? I don't think so. What if I pointed what you knew to be a real gun at you and you said, "Is that loaded?" And I said, "Well, I don't personally know, but someone else told me it wasn't." Would that relieve your concern that I was threatening you with death or serious bodily injury, even if unintentionally? Of course not. But that essentially is the argument the defense is trying to make in their motion. The defense is trying to say, as long as our client, Alec Baldwin, didn't know whether or not the gun was loaded, he was not acting recklessly. In order to act recklessly, he had to have affirmative subjective knowledge that there was a bullet in the gun. And the state has to prove that beyond a reasonable doubt. And the state's not even alleging that. The state's not alleging that Alec Baldwin knew there was a bullet in the gun. And of course, the state's not alleging that because the state doesn't believe that's required for involuntary manslaughter. The defense is saying unless Alec Baldwin knew there was a bullet in the gun, it can't have been recklessness, can't have been involuntary manslaughter. And I would remind you all again that of the drunk driving analogy. So you get drunk at a bar, you get behind the wheel of your car to drive home, you're not intending to run anybody over. If you do run anybody over and kill them, it's unintentional, but it's reckless. You know you're creating an unjustified risk of death to others when you engage in drunk driving. And if you do run somebody over and kill them, it's involuntary manslaughter. Does it make sense that it could only be involuntary manslaughter if you affirmatively knew there were going to be pedestrians on the street? That if it was only possible that there would be people on the street, that it could never be involuntary manslaughter for you to drunkenly kill someone with your car on the way home? The only way that could be involuntary manslaughter is if you had affirmative subjective knowledge that there would be people in the crosswalks on the way home. Does that make any sense to anybody? Does involuntary manslaughter require that under New Mexico law? Involuntary manslaughter consists of manslaughter committed in the commission of an unlawful act, not amounting to a felony. Where does it say you have to have affirmative knowledge that there's a bullet in the gun or a pedestrian in the crosswalk? Of course it doesn't. Or involuntary manslaughter consists of manslaughter committed in the commission of a lawful act, which might produce death. Does drunk driving do that? Well, of course, drunk driving itself is an unlawful act. Even if you're handling a gun in an otherwise lawful way, and I would argue that Alec Baldwin's not here because New Mexico has this negligent handling of a gun misdemeanor, or without due caution and circumspection. If you're handling what you know to be a real gun and you don't personally ensure that there's no live ammo in the gun, which could mean you check the gun yourself. It could mean you call the armorer over or the first assistant director over, preferably the armorer, because in this case, apparently David Hall really had no idea how to ensure the safety of a gun. Neither did Hannah, but given her job title, she was presumed to know. Call the armorer over, have the armorer empty the gun in front of you, show you the dummy rounds, and then load them back in your presence, and then you take the gun in hand. That's due caution and circumspection. And that didn't happen here. We know. But if you don't do that, if you don't ensure with certainty that there's no live ammo in the gun, and then you point that gun directly at another human being, cock the hammer and press the trigger, does that combination of conduct qualify as due caution and circumspection in the handling of what you know to be a real gun? And we know Alec Baldwin knew it to be a real gun because he told detectives that day, within hours after the shooting, that he knew he was handling a real gun. He knew, by the way, the difference between live ammo and dummy ammo and blanks, because he explained at length to the detectives what the differences were. This was not a naive man, incompetent at ensuring safety with this gun. He had the competence, the special training and expertise to know whether or not that gun was loaded with live ammo. He could have done it himself, or at the very least, there was an armorer feet away. He could have had to do that. He knew of the risks of not ensuring there was no live ammo in the gun in combination with his other conduct, pointing the gun directly at Halyna Hutchins, cocking the hammer, pressing the trigger. It's that combination of conduct and the failure to ensure no live ammo in the gun that collectively qualifies as without due caution and circumspection. And it resulted in the death of Halyna Hutchins directly. There's no dispute, factual dispute of that. And therefore it qualifies as involuntary manslaughter. Now, the defense has a problem because the facts that lead to conviction for involuntary manslaughter are really uncontested. No one is saying that Alec Baldwin made any attempt to ensure there was no live ammo in the gun when the gun was placed in his hand. No one is arguing that he did not point that gun directly at Halyna Hutchins. No one is arguing that he didn't cock the hammer, not even Alec Baldwin. Now, Alec Baldwin does contest that he pressed the trigger. And with respect to that argument, I would just remind everybody that in the moments preceding the shooting, he was rehearsing his presentation of the pistol. Look at that red circle. He did it multiple times, and his finger was on the trigger each time. And FBI testing demonstrated the hammer could not be dropped in a manner to discharge a live round unless that trigger was pulled. So, of course, you can believe Alec Baldwin's self-serving statement, or you can believe the objective laboratory testing of the FBI. There's zero evidence that that hammer could be dropped in a manner to discharge a cartridge without the trigger being pressed. Now, I would argue that's not even required. I would argue that even if the gun were defective somehow, and the hammer could be dropped and discharged the cartridge without the trigger being pressed, it still qualifies as involuntary manslaughter, as a failure of due care and circumspection to not check that gun for live ammo, point it at Halyna Hutchins, and cock the hammer. And all that is undisputed. Alec Baldwin concedes to all that conduct. So the defense has a problem. Even under their own client's rendition of the facts, it qualifies as involuntary manslaughter unless they can make this ridiculous argument that this is all simply lawful, that this conduct admitted to by their client doesn't qualify as involuntary manslaughter because he lacked the subjective knowledge that there was definitely a live round in that gun. I don't believe that's the legal standard for all the reasons I've just explained. But I have not read this motion, by the way. I'm reading it for the first time with all of you. So let's see what they have to say. The motion, I'm going to jump right to, let's see. I'm actually not going to read the whole thing. It's 22 pages, and I don't want to read the whole thing. I just want to, I'll read enough to confirm that's the argument they're making. What I will do is I will embed the motion. I will put a PDF of the motion in the playback version of today's show, which will be publicly available. So for all my Alec Baldwin coverage, folks, you can go to, at any time, point your browser to lawofselfdefense.com/Baldwin, There it is at the bottom of the screen. lawofselfdefense.com/Baldwin. That's an aggregation page where I've put all my coverage of this event, this tragedy, this crime, and our legal analysis and coverage of the proceedings. Today's show will be there on a playback version, and in that I'll have embedded the motion. So you can 22-page motion. You can read it at your leisure, and it looks like the substance of it goes to starts at page 8. Let's see. Oh, I'll start here with the introduction because there's some nonsense here. Preliminary statement. The state has not alleged facts that constitute a crime, says Baldwin's defense team, even taking every allegation that the state has presented as true solely for the purpose of this motion, which is what's required here. So the defense has to say, let's assume everything the state says is true. Defendant Alec Baldwin could not have been aware of a substantial risk that his alleged actions could cause the death of Halyna Hutchins because he had no reason to believe that the firearm contained live ammunition. All right, well, there it is. Unless Alec Baldwin had reason to believe that the firearm did, not could, but did contain live ammunition, he simply can't be criminally liable for his conduct here. Then the defense gets into a bunch of verbal sleight of hand and misdirection. The parties were in a movie set. Okay, what's that mean? Where the prospect of live ammunition being present is incomprehensible. Is that true? Now, that was in an emotive statement by, I believe, David Halls on the set. It might even have been by the prosecutors, but it doesn't matter. It's a motive. It's not a statement of fact or law. And we know that the industry itself does not believe this. The industry does not believe that just because a real gun is on a movie set, the industry doesn't believe that the prospect of live ammo is incomprehensible. How do we know? Because the industry tells us. When there's a live gun on set, it's definitely not incomprehensible that there's live ammo in the gun. That's why we have all these additional safety rules. Don't point the gun at anybody. Why? If it was safe to assume, if it was incomprehensible that there could be live ammo in that real gun, why would we need this rule about not pointing the gun at people? If the gun literally has no ammo in it, pointing it at someone can cause no harm. You wouldn't need this rule if it was literally incomprehensible that there could be a live round in the gun. We have this rule because we know it is comprehensible that there could be a live round in the gun. Any object at which you point the firearm could be destroyed. None of the gun has no live ammo in it. That caution presumes the possibility of live ammo in the gun. Never place your finger on the trigger until you're ready to shoot. Why would that matter if it was safe to assume the gun had no live ammo in it? The only reason to have this finger on the trigger rule is out of concern that the gun might discharge a live round. So it's not incomprehensible. That's all just emotive nonsense. Both the armorer and the assistant director had opened the chamber, examined the ammunition immediately before handing the gun to Baldwin. At that moment, the assistant director announced to the crew cold gun, which led everyone to believe the gun contained only dummy rounds, as the state has also admitted. At that point, everyone certainly assumed that there wasn't a live round. Does that relieve you of criminal liability for mishandling a firearm in such a way as to kill someone? Well, I thought the gun wasn't loaded. Did you check? No. Did you know for certain? No. You just assumed because someone else told you that the gun was not loaded. And based on their representation, you chose deliberately to point that gun at another human being, cock the hammer, and press the trigger. Well, guess what? If you do that, you know handling an inherently dangerous instrument, that mishandling creates a risk of death or serious bodily injury. You ignored that risk. And then you bear the criminal liability for involuntary manslaughter. The state has not even alleged that Baldwin had a subjective awareness of a substantial risk that the firearm held live ammunition. There's always a risk, a substantial risk, that a gun contains live ammunition. That's the nature of a real gun. That's why we have these safety rules. There is no body of gun handling safety that says it is safe to assume the gun's unloaded. None, anywhere. Not in the NRA gun safety handling guidelines, not in the Jeff Cooper gun safety handling guidelines, not in your grandfather's gun safety handling guidelines, not in the Screen Actors Guild gun safety handling guidelines, not under New Mexico law. So this is all sleight of hand. This whole argument, which I don't even need to read the rest of the motion, this is the premise of everything that follows. Unless Alec Baldwin affirmatively knew there was bullets in the gun, he can't be liable for involuntary manslaughter. The whole point of involuntary manslaughter is that you did not intend to hurt the person, that you knew there was a risk, an unjustified risk, and you ignored that risk. And by the way, for people who might argue that, well, maybe it wasn't a substantial risk. What's substantial mean? Do you think under New Mexico law, if someone were drunk driving, 0.2 blood alcohol level, okay, multiple of the drunk driving limit, they're completely shit-faced and they're drunk driving and they run over a grandmother with her walker in the crosswalk and kill her, that if they were to say, well, listen, I knew there was a risk that could happen, but it wasn't a substantial risk because, listen, I got to be honest, that defendant might say, I've literally driven home shit-faced from that bar 1,000 times. 1,000 times. And this has never happened before. So at worst, this is a very, very small risk of this outcome. Does that save that drunk driver from involuntary manslaughter? No. So you say, well, normally on a movie set, there's not a bullet in the gun. Sure. But the risk is there, and the risk is of death and maiming. And the effort to mitigate that risk takes literally moments. What's the balance of interest here? When you know the risk. Now, Alec Baldwin potentially could have believed that he was holding the equivalent of a blue gun. When he was interviewed by detectives, he might have said, listen, this had all the characteristics of an inert prop. Now, what might those characteristics be? Like, I tried to cock the hammer and it didn't move. It was like glued down. It was a molded part of this plastic prop gun. So it was incapable of firing a bullet. I don't know how that bullet came out of there. That might have been a legal defense. Maybe then he could argue that based on that knowledge, his direct, not relying on someone else's word, his direct knowledge, there was no way he could have been aware of a risk of death or maiming to Halyna Hutchins. But that's not what he said. When he was interviewed by police detectives, he said, oh, yeah. Very clever, by the way, I have to say, of the police. Maybe it happened by accident, but maybe it was on purpose. Very clever of the investigators to assign two reasonably attractive women to interview Alec Baldwin, to interrogate Alec Baldwin. Because if you watch that interview, he is puffed up like a peacock. He, the big Hollywood star, getting an opportunity to impress these podunk, backwater women, detectives, on how sophisticated he is. He knows this. Hey, listen, we handle real guns. This was a real gun. That's why we're so careful. We know we're handling real guns. I knew this was a real gun. I know how to tell the difference between live ammo and dummies and blanks. Look, here's examples. I can explain to you what the differences are. All to impress them while they giggled and did their little hair toss thing. What a fool. All right, so let me take just a Of course, we look at the questions from the Law of Self-Defense members for free. Try out Law of Self-Defense membership for just 99 cents, a 2-week trial membership at lawofselfdefense.com/trial. If you stay a member, it's still dirt cheap. It's only about 30 cents a day. Less than $10 a month to be a Law of Self-Defense member and get all your questions and comments on these live streams addressed for free. Or if you insist on posting your questions and comments on YouTube and want me to address them there, they have to be a minimum $10 super chat. $10 super chat. So let's see if I can tell when this one came in. I think I missed this one from Saturday when we covered the motion to dismiss. Oh, darn it. So I'll address it today because it's still timely. From John. John, $10 super chat. Thank you so much, John. He asks, if the judge throws out the indictment, do you think Alec Baldwin ends up taking a plea bargain? Oh, I did address it last week, last Saturday. I remember now. But I'll cover it again for those of you here who might not have been here Saturday. John asks, if the judge throws out the indictment, as the defense was asking, and in the hearing we covered Saturday, do you think Alec Baldwin ends up taking a plea bargain with no jail time? So my answer is Alec Baldwin's not going to get offered a plea deal. You can't just take a plea deal. One has to be offered to you in order to take it. The way the defense has dealt with Special Prosecutor Carrie Morrissey has been extremely offensive, basically accusing her of being unethical, of being motivated by malice in her prosecution, of lying, of misrepresenting to the court, disparaging her professional integrity and really her human integrity in almost every way imaginable, short of just calling her a whore. That's not the kind of conduct towards a prosecutor that leads that prosecutor towards offering your client a plea bargain. That leads that prosecutor to saying, all right, that's how you feel about it. Let's argue the merits at trial. That's how I would feel if I were in Carrie Morrissey's position. And I believe that is how she feels, because it's obvious that she has taken personal offense at these derogatory characterizations about her by this defense team. Plus, she had offered Alec Baldwin the same plea deal that David Hall was offered. Basically, plea to a misdemeanor, and you'll get no time served, 6 months unsupervised release. And Alec Baldwin said, no, I'm going to trial. I want to go to trial. So once you turn down a plea, you're not getting another plea under the best of circumstances. And these are not the best of circumstances. So no, this is not happening. Alec Baldwin's, unless, of course, the court dismisses the indictment, Alec Baldwin's going to trial. And if the court does dismiss the indictment, I've heard people say that then that ends this, that he can't be indicted again. That's not the case. So in theory, the court could dismiss the indictment, the manslaughter indictment, with prejudice, and then it's over. Then there's nothing else the state can do. Alec Baldwin's in the clear. I would be shocked if that were to occur. Frankly, I would be shocked if the court dismissed the indictment, although it's possible. We covered the hearing, and Judge Morrow did seem hostile, maybe too strong a word, but Judge Morrow was quite aggressive with Carrie Morrissey. Based just on that aggressive questioning, challenging of Prosecutor Morrissey, I wonder if the judge might actually dismiss this indictment. But if she does, I would expect her to dismiss it without prejudice, and we would just see a new grand jury impaneled and another indictment achieved, I would expect. Let's see. So that's that. All right, let me take a look at the Law of Self-Defense members and see what our membership has to say. Jeffrey says, the blam on today's thumbnail. There it is. Whoops. Reminds him of the old Batman movies. Yeah. Kapow. I guess you have to be of a certain age to have seen the old Batman television series. It was great stuff. Probably the best Batman, I think. At least the bad guys were the best. The Joker, the Penguin, Catwoman. I think those were the best versions of each of those characters, in my humble opinion. Let's see. Yeah, when I saw it as a kid, I kind of took it seriously too. You know, you're 7 or 8 years old. It's like, oh, it's an action TV show. You have to be of a certain age, I guess, to get the satire. Kyle says blue guns are weighted too. Yeah, they're weighted to be similar or identical in weight to real guns. Denver says, is it clear that the state's allowed to refile? Based on what I'm hearing in these conversations, these hearings, my impression is that unless the indictment is dismissed with prejudice, the state is free to refile. Let's see. Jeffrey says, when I've taken force on force training with CERT training guns, these are guns that when the trigger's pressed, they fire a laser beam. They're not capable of firing real ammo. So they're completely safe in that regard. Everyone was required to check them to confirm they were inert before training, even though they were marked and had no barrel. Yeah, so I've done quite a lot of training with simunitions, for example. Simunitions uses real guns. But the cartridges that are loaded into the guns, instead of having a bullet on the end, they have a little tiny paint pellet, and special barrels are used in the gun that could only pass the little paint pellet, not a real bullet. But we were frisked, we were patted down um, for any live ammo, for anything that could create a risk. So that's the kind of due care and circumspection that's required. We were patted down in each other's presence, all the participants in the class. By the way, those things hurt like an MFer, those little simunition pellets. Let's see. Bup, bup, bup. Uh, bup, bup, bup. Jeffrey says, asking Kyle. Kyle's another member who's in the chat here, law enforcement or former law enforcement. Don't the police check their guns to make sure there is a live round? I can tell you, folks, I put a gun on every morning, and when I put my gun on, I do a chamber check and I check the mag. That precise reason. I want to make sure there's a live round in that gun and the magazine. Load it up. Kyle says they clear it and check it before placing it in a locker, like when they're going into a secured area, like a jail or a prison. You don't want to bring a gun with you into that environment. So, of course, I've never been a cop, but I've been around plenty of jails and prisons and police with guns in these circumstances. Often there's a kind of a tube-like device with sand at the bottom, and you would take the magazine out of your service pistol, eject the live cartridge, then point the presumptively unloaded gun down this tube and drop the hammer or drop the striker by pulling the trigger, get a click, and that's the ultimate insurance that there's no live round in the gun. And if there is a live round, it would get fired down into the sand or whatever capture mechanism is at the bottom of the tube. And then you stick it in a locker that you lock. So even when you know the gun's going into a locker and won't be accessible to other people, you still engage in due care and circumspection to make sure there's no live rounds in the gun. Does anybody think that if this scene on Rust had called for Alec Baldwin to put the muzzle of that revolver against his own head, cock the hammer, and pull the trigger, he would not have absolutely ensured there was no live rounds in that gun? Why do they need a grand jury? Is that New Mexico law? Um, Apparently, different states do this in different ways. So not every state requires a grand jury. Grand juries are quite Expensive. Expensive in terms of the court's own time and resources, and also in terms of the people involved. So a grand jury is typically not 6 people or 12 people like a trial jury. It's often 20 plus people. They're not usually sitting continuously, but over a period of months, they meet repeatedly. And in a given day, they might hear probable cause arguments from a prosecutor on 6, 8, 10 different cases, and return an indictment, or alternatively return a no true bill, a not indictment. Um, but because of the kind of the burden of actually operating a grand jury, there are states that have moved away from grand juries. Florida, for example, unless it's a capital crime being charged, Florida allows for what's called an information, which is a sworn statement from the prosecutors setting forth their argument for probable cause and the evidence to support that probable cause. And that information, that sworn affidavit, goes before a judge, and the judge reads it, and the judge finds it credible. The judge signs off, and that's the equivalent of an indictment. George Zimmerman, for example, was never indicted by a grand jury, probably because the prosecutor, the state, didn't believe they could secure an indictment in his case. They went with information instead. An information, by the way, which turned out to be the claims in the information were false. But nevertheless, it was enough to drag George Zimmerman into court. Now, you may be feeling like, hey, if I'm charged with a crime, I want the less convenient, more resource burdensome, but more protective form of a actual grand jury. So the prosecution has to make their probable cause argument to those 22, 25 people of a grand jury, and they have to decide to return an indictment. I want that. I don't want this information nonsense, because the information thing sounds like a rubber stamp, and it is a rubber stamp. So when a prosecutor presents an information, it's rubber stamped by the judge they give it to, and off the trial you go. And if it's later discovered the information was bullshit, too bad, too late, you're still going to trial. Shouldn't be that way, but that's the way it works. Unfortunately, grand juries also tend to be rubber stamps. So we've all heard the expression, right? A prosecutor could get a grand jury to indict a ham sandwich. And that's because the grand jury is not really an adversarial process. The only people the grand jury really hears from in person are the prosecutors. So if you only hear one side of an argument, it generally sounds pretty compelling. So grand juries tend to be pretty rubber stamped too. We pretend that they're not. And a lot of the argument we're seeing here in the Alec Baldwin case is really illuminating, in the sense that what the defense is arguing, the defense here is arguing for a version of the grand jury that I think we would all prefer, where there is much more robust representation of the defense side of the narrative of innocence to the grand jury, than typically takes place. I think one of the things that Kerry Morrissey's running up into is that grand juries are typically run in a typical way, and they're typically rubber stamps. And that's how it's normally done. That's normal practice, and no one ever questions it. But now Alec Baldwin's highly paid Manhattan litigators are questioning it. They're coming at it. See, a normal, like, local New Mexico criminal defense attorney might just say, well, we can't really challenge it because that's how it's normally done. These New York lawyers are not saying that. They're saying, no. There's actually much more rigid requirements for a grand jury to be legitimate, an indictment to be legitimate. And we're going to hold the state to that more demanding standard. Now, whether or not you think the defense here is correct on the merits of their arguments, certainly the principle is something that would be hard to dispute, right? If there are more demanding standards, then the defendant, whoever that is entitled to those, and should receive that due process of law. Let's see. What else? More questions came in. Let me take a quick look at the super chats, just in case. Yeah, good. I would prefer that you folks not do super chats. I would prefer that you do the membership, because it's much more cost effective for all of you. And of course, if you're members of Law Self-Defense, even less than 30 cents a day, that's something that if YouTube has a bad day and decides to cancel my YouTube channel, they can't take my own members away from me, and can't take you away from Law Self-Defense. can't take law of self-defense away from you, I should say. Let's see. Denver, law of self-defense member Denver says, you can tell at the hearing, which I covered, it was last Friday, but I covered it on Saturday morning. And again, that's at that URL here, lawofselfdefense.com/Baldwin. You can tell at the hearing that Morrissey was outraged by the defense and to some extent with the judge's approach. She was pissed. Yeah. Yeah, she was. Leroy says, $10 says Baldwin is working on a post-prison career comeback in the background. Big career boost. Well, I mean, I've mentioned this before, but it's quite possible that what Baldwin's defense counsel is really seeking, of course, they'd love to get the indictment dismissed, right? And they would love for Baldwin to be acquitted at trial, should it go to trial. But I think a realistic view of the law and the facts here suggests that a conviction is all but certain if it goes to trial. And even if this indictment were dismissed, that if another indictment were sought, and I would expect that to be the case, that it would be secured. That the defense counsel's real strategic goal here is not so much to avoid conviction, which may seem impossible, but to position Baldwin for rehabilitation after the conviction by being able to argue, hey, this conviction was unjust. I mean, we were arguing even before the trial about all the unjust things happening here. You can see all the motions, you can see all the arguments, all the hearings. And therefore, everyone should believe that despite this conviction, the conviction is so inherently unjust that it should be disregarded. Let's see. Yeah, the downside, of course, one consequence, I guess I should say, of the defense's very vigorous approach is whatever setting Morrissey was on for the Hannah Gutierrez prosecution, just double that. Just double that. Let's see. All right, I think that's everything, folks. So I'll go ahead and wrap up at this point. I'll just remind all of you that if you carry a gun, before I do, just a last reminder, CCW Safe, provider of legal service memberships. In effect, they pay their members legal expenses if they're involved in a use of force event, and they do much more as well. There are other companies that offer similar services. Some of them are worthy of consideration. Some of them are dumpster fires. I find CCW Safe is the best fit for me. If you'd like to see if they're the best fit for you, and I think they might be, I have a little video that explains why I chose them at lawofselfdefense.com/trust, why I trust CCW Safe. And if you go to that URL, there's also a discount code you can use for 10% off your own membership at CCW Safe. Again, that's at lawofselfdefense.com/CCW Safe. And a reminder that if you carry a gun, so you're hard to kill, if you carry a knife, if you carry pepper spray, if you study jujitsu, so you're hard to kill, I do all those things. So I'm hard to kill, so my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. And that's what we try to help you do here at Law of Self-Defense. Until next time, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.